Committee on Oversight and Government Reform will come to order. Without objection, the presiding member is authorized to declare a recess at any time. I want to welcome our guests. I will introduce you individually in just a moment, but for now, I'll recognize my friend from North Carolina for his opening statement, Mr. Meadows.
Thank you, Mr. Chairman. Thank you for your leadership in calling this hearing. Obviously, federal agencies have a very active role assigned to them by Congress, and what they do touches the daily lives of the public. There's no doubt that federal agencies play an important role in our government, but they should still play by the rules laid down by Congress when it comes to issuing the rules themselves. The rulemaking process has changed over time and can get very technical, but what has not changed is only Congress can legislate and agencies cannot issue regulations unilaterally. Rules are supposed to be issued in accordance with several statutes and executive orders, but as is the case with this hearing today, and it will show today, that this doesn't always happen. In fact, in 2016 alone, 18 regulations were issued for each law passed by Congress, not to mention the hundreds of pages of guidance that came along with those regulations. And according to the Federal Registry, agencies issued 3,280 rules last year. Now, this amounts to just a little bit less than 9 rules per day, including weekends and federal holidays. Now, that's an improvement over the previous administration where we saw 10.5 rules passed each day in 2016. Now, several laws and executive orders establish a regulatory process designed to require agencies to consult with the affected parties, evaluate their benefits, and certainly the compliance burdens and other costs, and consider alternatives to regulating. Now, we know federal agencies are not consistently following the rules Congress and the President have established. In fact, recently, GAO released the findings of an audit concluding that agencies have become increasingly non-compliant with the Congressional Review Act. And when issuing rules at the end of a presidential administration, this is particularly evident, especially when they have significant impact. Those rules which actually cost the economy at least $100 million. Agencies also issue guidance, which is a statement of policy or an interpretation of the law or regulations. Generally, guidance is supposed to inform the public of how to comply with those laws. Unfortunately, we don't know how many guidance documents agencies have issued, nor do we know how much it will cost the economy. One of our witnesses today has written that while no one knows how many guidance documents are out there, everyone agrees that the total is oceanic in scale. Late last year, our committee launched an oversight project on regulatory guidance documents. In response to our December request, agencies provided information on more than 12,800 documents. Now, the final number is still rising as agencies continue to produce the information. Agencies have also had difficulty in complying with the few existing requirements for issuing guidance documents. In fact, in 2015, the GAO undertook an audit of the Department of Agriculture, Education, Health and Human Services, and Labor, and found shortcomings in complying with applicable requirements. The committee's oversight project also found widespread noncompliance with the CRA and the executive directives. Agencies reported to the committee that they had submitted just 189 guidance documents to Congress and the GAO as it is required by the CRA. That's a submission rate of less than 0.015%. In the last 5 months, GAO has issued 4 opinions to members of Congress finding certain guidance documents are considered rules under the Congressional Review Act and therefore must be submitted. Now, in conclusion, we know that more congressional requests for opinions on whether certain guidance documents are pending before the CRA. Clearly, GAO will never be able to review the more than 12,800 guidance documents in our limited sample, let alone the entire universe of the agency guidance. And there is some sort of disconnect between what the law says and what agencies do. So we look forward to hearing your testimony today and you shining the light on this regulatory process as we try to make sure that we do what is according to the law and the rules and upholding the will of Congress. I yield back.
Thank the gentleman from North Carolina. Would now recognize the gentlelady from New York to give her opening statement.
Thank you, Mr. Chairman, for calling today's important hearing, and thank you to all of our witnesses here today. I would like to start by making one important point. We all agree that rules and guidance documents should be fair, open, and informed by those entities and individuals who are regulated by them. However, we cannot simply eliminate them. That would result in chaos. I want to point out that it is often members of the business community who want regulations and guidance because they want certainty. They want clarity. That is critical for them to determine how to invest their time and their resources. Guidance documents, even though they are non-binding, are often very useful to regulated entities in explaining how they can stay on the right side of the law. The chairman has invited Professor Nicholas Perillo to testify today, and I'm pleased that he's here. He issued a report highlighting this point, and he based it on interviews with business representatives who stress the importance of guidance documents. For example, Mark Friedman, the executive director of the labor law policy at the U.S. Chamber of Commerce, and I quote, acknowledged that business sometimes demanded guidance and that it was quite reasonable for the agency to provide it to clarify vague legislative rules, end quote. Let me give you an example. Industry groups recently asked the IRS to issue guidance about the new tax law. The American Institute of Certified Public Accountants wrote to the IRS that specific areas, and I quote, need immediate guidance in order for taxpayers and practitioners to comply with their 2017 tax obligations and to make informed decisions regarding cash flow, entity structure, retirement, wealth transfer, and a vast number of other tax planning issues, end quote. Professor Perillo summarized his findings by writing this, and I quote, it was clear from these interviews that guidance increases an agency program's integrity and efficiency and shields regulated parties against unequal treatment, unnecessary work, and unnecessary risk, end quote. Guidance works best if there is ongoing interaction between regulators and the regulated entities. This interaction can take the form of conversations with stakeholders, advisory committee meetings, town halls, or even requests for public comment. But we need to avoid placing an overwhelming burden on federal agencies. Guidance documents are effective precisely because regulators can issue them more quickly than federal rulemaking. Imposing burdensome requirements on guidance documents will mean that agencies will stop using them, depriving the business community and others of this very useful tool. Formal rules are different because they carry the force of law. They are governed by statutory procedures that require formal public participation and the opportunity to appeal to the courts if these processes are not followed. This has been the law since we enacted the Administrative Procedure Act in 1946. My concern is that there are multiple recent examples of the Trump administration attempting to circumvent the Administrative Procedure Act or issue agency guidance that is not even public, which leads to less transparency and certainty, not more. For example, just last week, the Inspector General for the General Services Administration issued what I thought was an excellent report, finding that the agency's guidance on how the staff communicate with Congress, and I quote, lacks transparency, end quote, and completely omitted whistleblower protection language that is required by the Whistleblower Protection Act. Specifically, the IG found that GSA, and I quote, created opportunities for confusion, misinterpretation, and inconsistent application among its officials and employees, end quote. According to the IG, GSA followed oral instructions from the White House to stop responding to oversight and investigative requests from members of Congress other than committee chairs. GSA officials communicated this new policy to staff in, quote, small in-person meetings, end quote, and through, quote, telephone calls and hallway conversations. And I'd like a unanimous consent to put this excellent report in the record outlining these conflicts.
Without objection.
In another example, the Department of Labor is withholding from the public an economic analysis of its proposed rule to allow employers to take the tips from restaurant workers and other employees. According to press reports, the department did not publish its analysis, which showed that, quote, employees would lose out on billions of dollars in gratuities, end quote. Hiding from the public an analysis conducted by the agency, especially when it contradicts the agency's own proposal, is the opposite of transparency we expect in the rulemaking process. For today's hearing, I am very pleased that we will be able to shine a light on the federal regulatory process, and I look forward to the testimony. This is Sunshine Week, and after all, as the saying goes, sunlight is the best disinfectant. I hope we can apply that disinfectant across the board and not limit it only to those issues with which some may disagree. Thank you, Mr. Chairman.
I thank the gentlelady from New York. We are pleased to have a distinguished panel of witnesses / experts. I'm going to introduce you en banc and then recognize you individually for your opening statement. First, to my left, Ms. Chris Nguyen, Acting Director for Strategic Issues at the Government Accountability Office. She is accompanied by Mr. Robert Kramer, Managing Associate General Counsel at GAO, who will also be sworn in just a moment. Mr. Paul No, Vice President of Public Policy at the American Forest and Paper Association. Ms. Karen Harned, Executive Director, National Federation of Independent Business, Small Business Legal Center. Professor Nicholas Perillo, Professor of Law at Yale Law School. And Mr. Amit Narang, Regulatory Policy Advocate at Public Citizen. Pursuant to committee rules, I'm going to have to administer an oath to you, so if you would please rise, and we'll do that. Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, nothing but the truth, so help you God? May the record reflect the witnesses answered in the affirmative. You may be seated. In order to allow the members to ask their questions and to be good stewards of your time, I just want you to know your opening statements are all part of the record. If I can get you to limit your remarks to 5 minutes, and there are a set of lights in theory that are designed to help with that. So if you, I know a lot of our members have not figured out the lighting system yet, so I'll share it with you. Green, you're good. Yellow, speed up, try to get under the light as quick as you can. Red, if you could begin to maybe wrap up that final thought. So with that, Ms. Nguyen.
Chairman Gowdy and members of the committee, thank you for inviting me today to discuss federal regulatory and guidance practices. Agencies use federal guidance and regulations to achieve national goals, such as improving the economy and protecting the health and safety of the public. The importance of improving the transparency of agencies' guidance and regulatory practices is a common theme throughout GAO's body of work. At your request, this testimony focuses on 2 reports. Our 2015 report on regulatory guidance addresses selected agencies' adherence to relevant OMB requirements and internal controls. And our recently released report discusses agencies' compliance with procedural requirements for rulemaking, including the Congressional Review Act. Regarding our 2015 report, we found that USDA, Education, HHS, and Labor did not consistently adhere to OMB requirements when developing significant guidance. Specifically, agencies did not consistently follow OMB requirements for the development and dissemination of significant guidance. While some agencies had written procedures for their approval of significant guidance, others had none, or their procedures needed updating. We also found that 3 of the 4 agencies consistently applied OMB requirements for public access and feedback. However, 1 agency, HHS, did not. Agencies also lack adherence to internal controls for non-significant guidance. For example, most sub-agencies we reviewed did not have written procedures for producing guidance, and about half did not regularly evaluate whether issued guidance was effective and up-to-date. Non-significant guidance is not subject to OMB requirements. As such, application of internal controls is important to help agencies achieve effective guidance practices. In this report, GAO made 11 recommendations to the 4 agencies we reviewed. 3 of these recommendations remain unimplemented by HHS. HHS cannot ensure transparency and effectiveness of its guidance practices until it takes steps to improve its adherence to OMB requirements and internal controls. For the report GAO issued on Tuesday, we reported, among other things, 1, the number of regulations issued during presidential transition periods and their characteristics, and 2, agencies reported compliance with requirements for issued regulations. During the transition from the end of the Clinton, Bush, and Obama administrations to the next, the administrations published, on average, about 2.5 times more economically significant regulations during transition versus non-transition periods. Agencies more frequently provided advance notice to the public during transition periods, which provided the public opportunities to influence the development of these regulations. However, we found that agencies less often complied with the CRA in providing Congress time to review and possibly disapprove regulations. This inconsistent compliance with CRA also occurred during non-transition periods. Agencies' most common deficiency was the failure to provide Congress the required time to review regulations. In this report, GAO recommended OMB identify regulations at risk for not complying with the CRA and work with agencies to ensure compliance. It is important that agencies consistently provide Congress with the required time to review regulations throughout a president's term, and in particular, during a presidential transition when Congress typically has a larger number of regulations to review. Improvements made in transparency of the guidance and regulatory process benefit not only the public, but also improve congressional oversight. Thank you.
Thank you, Mr. No.
Thank you, Chairman Gowdy and members of the committee, for the honor to testify before you today on behalf of the American Forest and Paper Association and the American Wood Council. Regulatory transparency is an important and timely issue that really goes to the heart of our governmental system. Due process, transparency, and fundamental fairness and accountability. AF&PA and AWC applaud the committee for addressing this issue. For over 32 years, I have worked on regulatory policy, including in the Senate and the White House Office of Management and Budget, private practice, and trade associations. Having lived in the belly of the beast, I strongly believe there are many ways in which our rulemaking process could be more transparent and accountable. Today, I'd like to offer just a handful of problems and potential solutions. First, more light should be shined on the vast but often mysterious part of the administrative law universe, which is agency guidance, also called regulatory dark matter. To be sure, appropriate guidance can play a very beneficial role in regulatory programs, and I don't want to miss that fundamental point. But the truth is, nobody knows how many guidance documents there are or how to find them all. 11 years ago, when I was at the White House Office of Management and Budget, I worked on an OMB bulletin for agency good guidance practices that requires first, agency procedures for the approval and use of significant guidance documents. Second, standard elements. For example, agencies were directed to avoid inappropriate mandatory language. And third, public access and feedback procedures. Each agency was required to maintain on its website a current list of its significant guidance documents that were in effect. And there also was a requirement to provide for public comment and public requests for modification or repeal of guidance, as well as a presumption of pre-adoption notice and comment for economically significant guidance. The bulletin is rooted in longstanding recommendations of nonpartisan expert organizations, but unfortunately, both congressional oversight and GAO reports have shown, as you've just heard, that agencies have not been complying with this bulletin. Thus, I think Congress should elevate good guidance practices into statute, and I think an excellent first step would be enactment of the Guidance Out of Darkness Act, sponsored by Congressman Walker. I can't imagine why anyone would oppose a bill requiring federal agencies to post all of their guidance on a centralized, publicly accessible location on their website. Sometimes agencies have even gone further, and they've circumvented the notice and comment requirements of the Administrative Procedure Act to essentially regulate through guidance. Congress passes broadly written statutes, agencies follow with broadly written regulations, and then over the years, agencies fill in the gaps with highly detailed guidance. As the DC Circuit put it, quote, "The phenomenon is familiar. Law is made without notice and comment, without public participation, without publication in the Federal Register or the Code of Federal Regulations." I commend the Department of Justice for addressing the improper use of agency guidance, and I think more should be done on a government-wide basis. Second, for over 37 years, regulatory agencies often have circumvented the presidential orders requiring that regulations maximize net benefits to society by interpreting their statutes to preclude full cost-benefit balancing. This is a huge but unrecognized problem that undermines agency accountability and transparency and leads to unnecessarily wasteful and ineffective regulations that are not designed to enhance societal well-being. President Trump should take an historic step to ensure smarter regulation by directing the agencies, including the independent regulatory commissions, to interpret their statutes to fully allow benefit cost balancing unless prohibited by law. Third, agencies should be more transparent about key information supporting regulatory decisions. And finally, for the last 12 years, agencies have done a very poor job of complying with the Congressional Review Act. It clearly mandates that before a rule can take effect, the agency must submit the rule to Congress for review. And covered rules include both legally binding regulations and agency guidance documents. Various reports have shown that many rules have not been submitted to Congress since the law was enacted in 1996, and that's especially true for guidance. That raises questions whether these rules are legally in effect, and it also raises questions about Congress's ability to overturn those rules today under the expedited procedures of the Congressional Review Act, even if the rules were issued years ago. Thank you again for the opportunity to testify today. I would be happy to address any questions you may have.
Thank you, Ms. Harned.
Thank you, Chairman Gowdy, Ms. Maloney, and the rest of the committee for having this hearing today. On behalf of the NFIB, National Federation of Independent Business, I appreciate the opportunity to testify regarding making the federal regulatory process more transparent. Overzealous regulation is a continuous concern for small business. The uncertainty caused by future regulation effectively acts as a boot on the neck of small business, negatively impacting their small business owners' ability to plan for future growth. In a small business poll on regulations, NFIB found that almost half of small businesses surveyed viewed regulation as a very serious or somewhat serious problem. So it is not surprising to learn that America's small business owners view President Trump's commitment to rolling back unnecessarily burdensome and duplicative regulation as one of his administration's greatest accomplishments in his first year in office. Due in large part to the Trump administration's deregulatory agenda, small business optimism is at its highest level in decades, according to NFIB's survey on small business economic trends, which we do monthly. But much more work can and should be done to make the federal regulatory process more transparent and more accountable to the American people, particularly when it comes to regulation through guidance documents and other sub-regulatory pronouncements that impose new mandates on small business. The NFIB Small Business Legal Center outlined this phenomenon in our September 2015 report, The Fourth Branch and Underground Regulations, where we also cataloged these abuses. Make no mistake, as Paul just said, easy-to-understand guidance documents can be an effective tool to help small business owners understand their legal regulatory obligations. In fact, the Legal Center frequently directs small business owners to such helpful guidance documents like DOL's wage and hour tip sheets and EPA's one-stop shop page for small business compliance assistance. But there is a bright line between merely restating the law as it stands and establishing regulatory policy through guidance. A true guidance or advisory should do no more than restate the requirements of established law, ideally doing this as plainly and simply as possible. It should not impose new affirmative burdens on the regulated community. NFIB appreciates this committee's efforts to find solutions that will shine light on the regulatory process. In particular, NFIB believes that H.R. 4809, the Guidance Out of Darkness Act, would be a positive step forward in providing transparency of agency guidance documents and other sub-regulatory activities. We also think Congress should consider requiring agencies to organize guidance materials in some manner that is easily navigable and user-friendly. Additionally, NFIB respectfully offers one overarching principle for Congress to consider as it explores other legislative solutions. The regulated public should have a right to voice concerns over any newly announced policy, rule, or administrative interpretation of law that could impose affirmative regulatory burdens on them. Regardless of whether the rule in question might be characterized as legislative or interpretive, we maintain that it should only be adopted and enforced if it has gone through some form of notice and comment. Finally, NFIB commends Attorney General Sessions for setting an example for other agencies to follow with his November 16, 2017 memorandum that instructs Department of Justice officials to no longer issue guidance documents that purport to create rights or obligations that bind persons or entities outside of the executive branch. And we applaud then Associate Attorney General Rachel Brand for following up on that directive with an instruction earlier this year to heads of civil litigating components and U.S. attorneys that they are not to use the department's enforcement authority to effectively convert agency guidance documents into binding rules in affirmative civil enforcement litigation. NFIB encourages other agencies in the federal government to follow course and Congress to consider legislative solutions that would codify this practice. NFIB applauds this committee for highlighting the need to bring transparency to its regulation in all forms, including agency guidance documents. Such transparency is critical for America's small business owners who struggle to keep up with the myriad of regulations on the books while they run and grow their business. Thank you for having me testify today, and I look forward to your questions.
Yes, ma'am. Thank you, Professor.
Mr. Chairman. Thank you. Mr. Chairman, Ms. Maloney, and members of the committee, thank you for the opportunity to testify this morning. The principal basis for my testimony is a study of federal agency guidance documents that I conducted as a consultant for the Administrative Conference of the United States, for which I interviewed 135 individuals across a range of agencies, industries, and NGOs. The conference recently completed the process of adopting a new recommendation on guidance. I participated extensively in that process, and I broadly support the recommendation, though I am not testifying as a representative of the conference. The term guidance covers all general statements that an agency makes, short of issuing full-blown regulations, that advise the public on how the agency plans to exercise its discretion or interpret law. Guidance is an important means for increasing the transparency of regulation. When an agency chooses individual targets for enforcement or decides individual applications for licenses or benefits, the agency has the option to proceed case by case. The case-by-case approach can subject regulated parties to uncertainty and unequal treatment. Guidance redresses this problem by telling regulated parties, in a general, comprehensive, understandable way, how the agency plans to handle individual proceedings. Regulated parties often want this guidance and complain about not getting enough of it. On the other hand, guidance can undermine transparency if guidance substitutes for notice and comment rulemaking. Given these competing considerations, we confront what you might call a transparency trade-off. You can try to increase transparency if you mandate that any policy an agency makes about a certain matter has to be made through an open process like notice and comment. But an open process eats up scarce agency resources. So if the agency is strapped, it may react to this mandate by giving up articulating any general policy on the matter, which would be the worst outcome for transparency. In grappling with this trade-off, it helps to consider why guidance is exempt from notice and comment to begin with. Guidance, unlike a full-blown regulation, is supposed to be non-binding. The idea is that it's okay to issue a policy without the safeguards of notice and comment, so long as the policy is not cut and dried, so long as the agency in individual proceedings is flexible and open-minded when regulated parties argue for individual departures from the policy. But agencies are sometimes inflexible. One might assume that flexibility is an agency's path of least resistance, such that inflexibility must be the product of some conscious and nefarious purpose to treat guidance like a regulation. But that kind of blanket assumption is mistaken. Agencies face external pressures and unintended internal dynamics that can make them inflexible by default. The new conference recommendation suggests organizational reform measures to counter this inflexibility. Admittedly, many of these measures require managerial initiative and the commitment of resources, which may be in short supply. For example, an agency may inflexibly refuse to approve a company's request for a departure from guidance because the agency fears that the company's competitors will complain about an unlevel playing field, or that NGOs and the media will complain about favoritism. The conference explains how the agency can head off these complaints by being transparent and publishing reasons for the departure that become applicable to all similar cases going forward. But formulating defensible reasons is costly. To their credit, some agencies have sought to provide a degree of transparency and public participation on a wholesale basis when a guidance document is first adopted, measures that may approach notice and comment without going all the way. As my research and the conference recommendation indicate, the benefits and costs of such participation for the agency and the public depend on certain factors that vary a lot by program and document. Also, agencies undertaking these measures need to anticipate certain pitfalls. For example, if an agency promises to take public comment pre-adoption on more guidance documents than it has the resources to process the comments for, it may end up leaving a lot of documents in draft form indefinitely, which can cause stakeholder confusion. I'll be happy to discuss these matters and any others in response to your questions. Thank you.
Thank you, Professor. Mr. Narang.
Chairman Gowdy, Ranking Member Maloney, and members of this committee, thank you for the opportunity to testify today. I am Amit Narang, Regulatory Policy Advocate at Public Citizens Congress Watch. Public Citizen is a national public interest organization with more than 400,000 members and supporters. For more than 40 years, we have successfully advocated for stronger health, safety, consumer protection, and other rules, as well as for a robust regulatory system that curtails corporate wrongdoing and advances the public interest. Public health and safety regulation has been among the greatest public policy success stories in our country's history. Regulations have made our air far less polluted and our water much cleaner. They have made our food and drugs safer. They've made our workplaces less dangerous. They've made our financial system more stable. They have protected consumers from unsafe products and from predatory lending practices. They've made our cars safer. They've outlawed discrimination on the basis of race and gender, and much more. These regulations are now considered to be bedrock protections widely popular with the public. In short, our regulatory safeguards are to be celebrated and emulated, yet there is much more progress to be made in addressing threats to the health, safety, environmental, and financial security of hardworking American families. Unfortunately, President Trump and his administration are taking the country in exactly the opposite direction, embarking on a radical and unprecedented deregulatory agenda that is certainly pleasing corporate special interests by repealing regulatory protections at their behest, but at the expense of making everyday Americans less safe in countless ways. One of the key drivers of this administration's attack on public protections is Executive Order 13771, the so-called 2-for-1 executive order that requires agencies to get rid of existing regulations that protect the public in order to allow for new ones that protect the public. This executive order fundamentally conflicts with numerous statutes that Congress has passed to direct agencies to protect the public in a wide variety of areas, including food safety, consumer protection, environmental protection, auto safety, civil rights protections, and many more. None of these laws require, much less permit, agencies to only protect the public up to the point that it imposes no new costs on corporate stakeholders. I urge this committee to monitor agency decisions under the executive order to ensure maximum transparency when agencies delay, block, or are otherwise unable to finalize regulatory protections due to the executive order. Making matters worse, President Trump's claimed motivation for his deregulatory agenda that it will create economic growth has been proven flat out false. In January of this year, Goldman Sachs issued a report that found, quote, no evidence that employment or capital spending accelerated more after the election in areas where regulatory burdens are higher, end quote. Likewise, in its most recent annual report to Congress on the costs and benefits of federal regulations, OMB found that regulations over the last 10 years have provided the public with up to $800 billion in net benefits. Since the focus of this hearing is on transparency, I want to direct the committee's attention to a number of deeply troubling instances where agencies are rolling back regulatory protections while actively seeking to avoid transparency. The first example is the most urgent as it relates to language in the budget proposal currently being considered for FY 2018 that would exempt the EPA from complying with the Administrative Procedure Act when repealing the Clean Water Rule. Any attempt to carve out the repeal of the Clean Water Rule from compliance with the APA, as well as numerous other laws designed to provide transparency and accountability to the public, including the Freedom of Information Act, should be deeply troubling to all members of this committee in Congress, no matter their position on the Clean Water Rule. More broadly, it sends the message to the public that Congress is willing to give agencies a free pass on transparency and public participation when it comes to deregulation, but not when putting regulatory protections in place. I urge members of this committee to demand the removal of this rider on a bipartisan basis. Second, reports indicate that the Department of Labor deliberately withheld economic analysis it conducted for rulemaking that potentially would transfer billions of dollars from the pockets of restaurant servers and workers to the pockets of employers, as Ranking Member Maloney noted. What is even more unusual is that the rule was reviewed and cleared by the Office of Information and Regulatory Affairs, or OIRA. It is highly uncommon for OIRA to allow agencies to issue rules it has reviewed without any accompanying cost-benefit analysis. I encourage the committee to scrutinize closely OIRA's role in the refusal to release the analysis, which certainly has called into question the integrity of the OIRA review process. Finally, critical new guidance unanimously approved by the EEOC that would clarify workplace protections against sexual harassment, including based on sexual orientation, has been under review at OIRA since November with no indication when the guidance will be finalized. With renewed attention on the prevalence of sexual harassment in the workplace, this guidance is needed now more than ever. Beyond specific rules, agencies under the Trump administration continue to be evasive in disclosing the identities of the regulatory reform task force officers at agencies authorized to carry out President Trump's deregulatory agenda. Given numerous reports of conflicts of interest, this lack of transparency only adds to suspicions of regulatory capture by corporate special interests and further undermines the public's faith in government agencies acting in the public's interest. Transparency should not be a partisan issue, and there are opportunities to increase transparency in the regulatory process that deserve bipartisan support, both with respect to specific deregulatory actions taken under the Trump administration and broader reforms, such as making guidance documents more accessible to the public and ensuring that OIRA follows basic transparency provisions and requirements as stipulated in its governing executive orders. Public Citizen stands ready to work with members of this committee that seek to improve the effectiveness and transparency of regulations that protect working families and consumers. Thank you.
Thank you. The gentleman from Tennessee, Judge Duncan, is recognized.
Well, thank you very much, Mr. Chairman. About a year and a half ago, I read about a new book by a prominent Boston lawyer who was educated at Princeton and Harvard, and he wrote this. He said, quote, "The average professional in this country wakes up in the morning, goes to work, comes home, eats dinner, and then goes to sleep unaware that he or she has likely committed several federal crimes that day. Why? The answer lies in the very nature of modern federal criminal laws, which have exploded in number, but also have become impossibly broad and vague," unquote. And while that quote pertains to federal criminal laws, it really applies all over the scope of federal regulation. They have exploded in number to such an extent that the staff has provided us with an article from the Competitive Enterprise Institute entitled 10,000 Commandments. And they estimate in this article that the annual cost, the yearly cost of federal regulatory activity is costing our economy as much as $2 trillion a year. And what I've noticed over the years is that the more heavily regulated any industry becomes, it ends up in the hands of a few big giants. And I know the Congress several years ago passed the Dodd-Frank law. Before we passed that law, the 5 largest banks had 22% of total deposits in this country. Now they got 45%. And there have been hundreds of small banks and credit unions that have been either gone out of business or been forced to merge or have been bought out. And so we pass a law aiming at the big giants, but we hurt the little guys. And it seems that applies in almost every industry. Ms. Harmon, have you noticed that same trend?
Absolutely. I've seen it my whole career, including before I was at NFIB. We represented at my food and drug law firm a small business owner, actually a couple that were targeted by the DEA. And it was through that process, at the time they were trying to get the meth lab issue, which is an important one. But you saw through the regulations, through all of that, a more consolidated part of that industry. Later, you saw it in grocery stores when it came to WIC programs. And I've seen it, and you can really see it in so many industries. And Dodd-Frank is a perfect example. It was the community banks that were getting closed, not the big ones. And so there's a reason for this. The small business owner is the one doing the regulatory compliance. They do not have legions of attorneys to scour the regulations, the Federal Register, much less the guidance documents we're here talking about today.
When the FDA was small and far less bureaucratic than today, many years ago, we had very many small companies in the drug business. Now the drug business is in the hands of a few big giants. Mr. Noy, I saw you shaking your head up and down. Have you seen this in your industry?
Sir, I think it's an across-the-board issue, and you've even heard some of the leaders of the largest banks talking about how Dodd-Frank created a moat to help them keep competitors out. So there can be a very unfortunate effect where larger entities can try to use regulations as a barrier to entry to create a competitive advantage vis-a-vis smaller entities. I think that's true across the board.
I notice also in some of the material we've been provided that fewer than 200, the committee requested information on more than 12,000 guidance documents. Fewer than 200 guidance documents were submitted to the Government Accountability Office as required by the Congressional Review Act. Ms. McGowan, do you think it's accurate to say that the Congressional Review Act is being ignored by most of the agencies?
If you can hit your mic.
Sorry. Based on our recent work, we found that noncompliance with CRA does exist. for the periods that we reviewed, so during the transition periods as well as non-transition periods. So what it means is that the most common deficiency that we found includes that the provision for agencies to provide Congress with adequate time to review regulations.
Well, I can tell you, I was a lawyer and a judge before I came to Congress, and yet there's so many laws and rules and regulations on the books in this country today. I don't think they've even designed a computer that can keep up with all of them, much less a human being. And as this article this book I quoted from, I think it's accurate to say that almost everybody in this room has violated several federal laws, rules, and regulations. They didn't mean to, they didn't know they were, but with this explosion of laws, rules, and regulations, it's happening all across this country today. It's a very sad thing. I yield back.
I thank the gentleman from Tennessee. The chair recognizes the gentlewoman from New York, Ms. Maloney, for 5 minutes.
Okay, thank you, Mr. Chairman. In 2016, the Obama administration's Department of Health and Human Services sent a guidance letter informing states that it's against the law to terminate Medicaid providers, particularly family planning providers like Planned Parenthood, for ideological reasons. This guidance came at a time when some states were aggressively trying to ban and defund Planned Parenthood simply because they provide family planning services as well. They base their efforts on unsubstantiated allegations made by David Deladian, who circulated misleading and heavily doctored videos in 2015. I would point out that our very committee conducted an exhaustive investigation of these claims, and we concluded on a bipartisan basis that his allegations were completely false. Even our former chairman, Representative Chavez, went on national television to tell the world that we here on this committee found no evidence that they broke the law. He sat right here in this chair, and he said he, quote, found no wrongdoing, end quote. Yet some states and outside advocacy groups continue to cite these discredited claims as a rationale for continuing to target Planned Parenthood to this day. In January, the Trump administration rescinded the Obama-era guidance in a follow-on guidance letter to state Medicaid directors. Last month, Ranking Member Cummings sent a letter to the Department of Health and Human Services raising the concerns after a whistleblower provided documents showing that an extreme anti-choice group known as Alliance Defending Freedom was behind this rescission. The whistleblower provided a draft guidance letter written by the group, and it appears that HHS rescinded the Obama guidance at the urging of this group. So I'd like to ask Mr. Narang, in your view, is it a best practice to consult secretly with one outside group while not consulting at all with other groups that would be affected by agency guidance?
I do think that sounds like an improper use of guidance in this instance, and it is troubling to me that it potentially was adopted at the behest of one particular individual or group.
And should HHS have conducted additional informal outreach to other stakeholders, such as Planned Parenthood as well?
I do think that it would have been more appropriate to also include Planned Parenthood in guidance that would directly potentially affect them.
And Mr. Narang, what other steps should HHS have taken?
Well, as I was saying, I do agree that it would be an improvement to make guidance more accessible, which can be termed more transparent, but I think the key is making it more accessible to the public. So this type of guidance would have been helpful, clearly, to make it accessible to the public, potentially in draft form.
Okay, and Professor Perillo, you wrote a report on these issues that was the basis for the Administrative Conference Best Practices Guide. Would you agree that it is generally not a best practice to consult secretly with one outside group while not consulting at all with other groups that would be affected?
Ms. Maloney, there are a variety of means for agencies to take stakeholder input on guidance. One of them is targeted outreach, in which there's not a public announcement that the guidance is being considered, but rather the agency selects certain stakeholders to talk to. This has the
Since my time is limited, could I just specifically ask, what would have been the best practice in this situation?
In the case of targeted outreach, I think agencies would typically get diverse points of view, multiple sides.
Okay. The Obama guidance document clarified the law. It stated what the Social Security Act and accompanying regulations require. So, Mr. Narang, despite what the Trump administration may be trying to do, it cannot contravene federal law, correct?
Well, that's true, and it will likely end up in court if that's the case.
So at this point in time, under the law, states still may not refuse to provide Planned Parenthood with funding just because they have ideological disagreements with them. Is that right, Mr. Narang?
Guidance documents are non-binding.
Okay, my time is almost up, but I'd just like to close by saying it's good to hear that at least at this point in time, states cannot refuse to pay Planned Parenthood for Medicaid services lawfully provided. Thank you.
Gentlewoman's time has expired. So, Mr. Narang, I want to make sure that that last comment. So you're saying guidance documents are non-binding. That's your official testimony here today?
That's not just my official testimony. It is the very nature of guidance documents.
All right. The gentleman from Ohio is recognized for 5 minutes, Mr. Jordan.
I thank the chairman. I first want to start by just saying the assertions made by the gentlelady from New York, I couldn't disagree more. First of all, remember those videos that were produced. The day after the first video came out, Cecile Richards issued an apology. Last time I checked, you don't apologize unless you've done something wrong. And the group who said that they were heavily edited and changed, guess who that group was? Fusion GPS. We know how much you can trust them. Fusion, the same organization that was paid by the Clinton campaign, the DNC, to put together this dossier, salacious and unverified, not my words, former FBI Director James Comey's words under oath in front of a congressional committee. That's who said those tapes were heavily edited. You can't trust that. I mean, that was just ridiculous. Mr. Noe, let me get back to the subject at hand. So let me summarize like I think I'm summarizing, and I want your response. So when I look at what GAO reported and the work that the oversight staff has done in this area, it seems to me you could say some agencies are actually just skirting the whole rulemaking process altogether, trying to get around it. Some are actually exempt. The IRS has this memorandum of understanding that they don't even really have to follow the rulemaking, the CRA process. And then a whole bunch of them use the guidance rules versus actually going through the formal process. In fact, I think it was like 90% of the rules issued are actually guidance. Like 12,000 was what the staff determined, the committee staff determined. So you have all that going on, but yet we still have this CRA Act where Congress can get rid of some of these, and we can get rid of them, and we've done 16 in 1 year. So is that kind of an accurate sort of overall assessment? Some are skirting it, some don't even have to follow them. They're exempt, namely the Internal Revenue Service, and then those who do go through any kind of rulemaking process, it's largely guidance and not the actual formal rule itself. Is that accurate, Mr. Noe?
Congressman Jordan, yes, it is. I was the lead Senate counsel on the Congressional Review Act, and I can tell you it was Congress's intent that all the covered rules would be submitted, and they haven't been. And that's something everybody should be concerned about. I mean, I think the good news here is that it's very easy for the agencies to comply. We all have email. It's easy to send your rule to Congress, and they haven't done it. And unfortunately, this pattern of Congress imposing procedures for the purposes of transparency and accountability on the agencies, and as soon as they get hold of that mandate, they often make Swiss cheese out of it.
Why is the IRS exempt? I mean, one of the findings the committee staff and GAO found was only one of more than 200 tax regulations issued was determined by the IRS to be significant, which I find interesting. My guess is taxpayers might think more than 1 out of 200 is actually significant, but somehow the agency felt like only one was significant. So why are they exempt? Why do they get this special deal? Seems to me that's the one agency you'd want to make sure they're doing things exactly by the book and as transparent as possible, particularly in light of their history, recent history.
I guess it seems that they're exempt because they say so. I used to work at the Office of Management and Budget, reviewing rules. There's a memorandum of understanding about what rules should come over from the IRS. They have driven a Mack truck through that, and I would just refer you to the Wall Street Journal piece written by former Clinton OIRA Administrator Sally Katzen and former Bush OIRA Administrator Susan Dudley that points out that that should come to an end.
And it seems to me, in light of their recent history, an organization with the power and influence that the IRS has and exercises over Americans' lives, their history of specifically targeting conservative groups, they did it in a systematic way. They did it for a sustained period of time. They did it. Seems to me all the more reason to have them follow the rulemaking process and be subject to OIRA as we move forward.
I'm hopeful that...
Do you think we need legislation to do that, to overturn this memorandum, or what?
You know, I think maybe calling them up here and asking them to
we're more than willing to do that.
To that. One reason I say maybe it's Congress for to step in here is, honestly, I think, you know, they've had years to comply with these executive directives, and they have made Swiss cheese out of them. So I think they either need to come to an understanding with you all.
I think the chairman and I would be happy to call them back.
Comply, or else they're going to face legislation.
We probably bring you back too and talk about it when we have the IRS in here as well. But thank you, Mr. Noe. Thank you, Mr. Chairman. I'll yield back.
I think the gentleman's recommendation for a follow-up hearing with some of the individuals, so I can assure you that they will, not only will we have a hearing, but we will go ahead and follow up, and any recommendations for other potential witnesses who abuse the system would be welcome for this committee. The chair recognizes the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you, Mr. Chairman. Early in the Trump administration, there emerged a rule that, so-called 2-to-1 rule, will repeal 2 regulations for every new regulation. And I'm concerned with whether or not this rule violates the Administrative Procedure Act. Now, one can understand that a new administration might well want to overturn some regulations that they regard as burdensome or otherwise. That is perfectly rational, but is the APA, the Administrative Procedure Act, requires a rational basis for all parts of rule making. Now, sacrificing 2 for 1 does not seem to me to be a rational basis. Pass one rule that helps protect the air we breathe, get rid of another rule that protects the water we drink. I'm not even sure how one would proceed. Ms. Nguyen, do you think there could be an APA concern here, a procedural concern with the 2 for 1 rule?
GAO does not take a legal position.
I didn't ask you for your legal position. Do you think there could be a APA, surely you know about that, concern with a blanket 2 for 1 rule?
I'm Robert Kramer from the General...
Please sit down at the table so you may be heard.
Okay. I think the question you're posing is a legal question, whether there is a violation of some provision of the APA as a result of this executive order. We haven't considered that, so we can't express an opinion at this.
Do you think it's appropriate for you to consider that? I can understand you may not have done so. I'm asking you, is it appropriate for you to do so, given the regulations that have been overturned and the 2-to-1 rule?
When we receive requests from members of Congress for opinions,
I'm asking for an opinion now, and I ask you to write the chairman of the committee your opinion on whether the 2-for-1 rule is in keeping with the Administrative Procedure Act. Mr. Perillo, do you have a view at this point on that matter?
I have not studied the issue enough to give an opinion. The argument that a challenger would make would be that a particular rescission of a rule is arbitrary or capricious because the reason for it was in order to make room for this other rule that is not sufficiently related. On the other hand, there is, for example, some D.C. Circuit precedent to suggest that as long as the rescission of a rule can be justified on the official record, then political pressure regarding the choice that an agency makes between different possible regulatory choices, each of which could be justified in themselves, that's not untoward. Now, this is a controversial issue in terms of whether this D.C. Circuit precedent is a good idea, but that's to give you an idea of the arguments on both sides.
Ms. Narang, there's a court suit, and I understand standing has been an issue, but perhaps you could tell us the basis for an attack on the 2-for-1 rule.
Well, I think this is a very good question, and as much as I'd like to answer it, unfortunately, I'm not able to due to our pending litigation challenging the executive order as unconstitutional. It has not been resolved on the basis of standing just yet. The court has, my understanding.
What do you argue in court?
We are arguing that the executive order fundamentally violates the Constitution, certain clauses in the Constitution, namely the take care clause that the president take cares that laws are faithfully executed. If I could just take a minute to talk about the impacts, the real world impacts of this executive order and illustrate it. It is going to make it very difficult, if not impossible, I believe, for agencies to issue the most important and beneficial regulations to the public. Let's take the lead in drinking water standard rule. I think we can all agree it's much needed, and it will be enormously beneficial. It will likely be quite costly as well. And if it's necessary for the EPA to offset those costs, and we're talking about offsets that are not that available to agencies. Over the course of the last year, the administration said that they have only about $560 million in regulatory offsets. If the lead in drinking water rule costs more than $560 million but provides massive benefits that outweigh the cost, they still will not be able to issue the rule. And that's the deregulatory offsets for all agencies, just for one rule. It really is going to be very difficult to protect the public with this executive order in place.
Thank you very much.
Gentlelady yields back. The gentleman from North Carolina.
Thank you, Mr. Chairman. Ms. Nguyen, let me come to you because the gentleman at the end of the table, Mr. Narang, said that guidance is non-binding. In your expertise, would you suggest that the agencies view all guidance as non-binding?
Regarding our past work, looking at guidance, guidance is typically non-binding, but for the IRS, we found that they consider their guidance to be authoritative because their examiners are bound by the statutes and what they're able to do. We don't have a particular recommendation in that.
So is there a statute that would say that the IRS guidance should be binding and all other agencies should not? Is there a statute that says that? Not an interpretation, but a statute.
If I may
Sure.
No, there is no statute.
There is no statute, so there is no law that would suggest that the IRS guidance should be treated differently than other agencies. Is that correct? Is that your sworn testimony?
It's important to note why IRS, many of their...
I don't want you to opine. Is there a law that would suggest that the IRS guidance should be treated differently than guidance from other agencies? Yes or no?
There is no statute.
Okay. So if indeed there is guidance that they continue to put out that has the effect of law, would you suggest, and I'll let your counsel answer this, would you suggest that they're actually infringing on the legislative process of Congress if indeed they are putting forth guidelines and rules that have the effect of law but yet are not warranted by statute?
If the IRS,
I need you to speak into the mic.
sorry, if the IRS is issuing guidance that is binding on the regulated community, the public, that would be a violation of the APA.
Okay, so, and I agree with you, and so let me tell you the problem that I have here is because they've issued a number of different guidances, and we have a letter before the GAO right now as it relates to what I call the silent returns and the fact of the implementation of the Affordable Care Act. And so as we're asking you, and I understand you only have 2 reviewers that review this for the entire GAO, is that correct?
Actually, we don't have a dedicated staff to these.
So it's even worse than 2 reviewers, okay? So as we go with this, here's my concern. If the IRS is able to do rules and regulation at the pace of 9 to 10 rules a day, and our action under the Congressional Review Act would require a laborious month, 2-month, 3-month process to overturn that. Do you see how Congress would be at a disadvantage of them encroaching in on our legislative jurisdiction?
Certainly, you know, the Congressional Review Act was intended to give Congress the ability to oversee agency rulemaking and to place a check on old rulemaking.
So would you also, would the GAO also, and as I say, we have a request there, indicate that if indeed the IRS has not followed a statute that would give them the ability to write guidance, then they are ignoring they do not have really a legal basis for that guidance other than a memo of understanding. How could it be binding on the American taxpayer if indeed there's not a statute that would support their guidance and rulemaking?
If a person affected by the guidance challenged that in court, a court could rule on whether it is.
So are you suggesting, since I'm affected by that, are you suggesting that we should file a lawsuit against the IRS instead of just actually overturning or giving Congress the ability to overturn that? I guess here's my concern, and I'll cut to the chase on this long, laborious line of questioning. We have a request into GAO. GAO is wanting us to check with the IRS and the Department of Treasury to have them opine on whether they believe that their guidance actually is mandated. And you're telling me today with this testimony that they believe that they're in compliance. Why would we ask the very agency of whom they believe is doing it correctly to opine on whether they're doing it correctly or not? Why would it not be a GAO decision to say that this has the operation of rules and laws and is subject to the Congressional Review Act? And I'll yield back to the chairman, and if he gives you time to answer that, that's certainly within his purview.
I did find the gentleman's line of questioning to be long, but not laborious, so I would allow time for an answer, and fullest way you want to give it.
I'll be happy to answer the question. We've been asked to give an opinion on whether a specific IRS action is a rule for purposes of the Congressional Review Act. As part of our standard procedure, whenever we're asked questions of that nature, we do reach out to the agency because we need to hear their views on the law and come to an understanding of why it is that they did what they did, at least in their view. It's kind of like a judge, when he has to decide a case, has to get from both sides their view on the law. That's the process we're following. We're just trying to get the full picture legally so that we can hopefully make the right decision.
I do want to thank the gentleman from North Carolina who has become as much of an expert as any member of Congress can be in this important but difficult and challenging subject matter area. So thank Mr. Meadows. The gentleman from Iowa is recognized.
Thank you, Chairman Gowdy. Thank you to our panelists for being here today. I'm not a lawyer. I'm a career small business person. And a wise person once said the following, and it has stuck with me ever since: the complex favors the large. And someone mentioned it earlier in their testimony that regulations end up building moats around large businesses. In fact, over the last 8 years, regulations have driven industry consolidation. Call me old-fashioned, but I think industry, market forces, should drive consolidation if there is any, not regulations. I looked the number up. Under President Obama's administration, we added 20,642 new regulations on the books. I mean, we're called Regulation Nation, and yet we want our businesses to compete globally and provide good-paying jobs with good-paying benefits. Of course, we all want that, but we have a 600-pound sack of regulations on every business's back. Regulations have driven consolidation in the banking industry, Dodd-Frank, healthcare industry with the ACA Act, agriculture. I'm from Iowa. I don't know about you, but I don't think it's good for our country. It's not good for our citizens to have 5 companies controlling our financial sector, 5 companies controlling our food supply, 5 companies providing our health care. Now, we have a lot of lawyers in Congress, probably too many, actually, with all due respect. We need more people who have met a payroll. Most folks have never met a payroll. I've met a payroll for over 20 years. So I'd like to ask Ms. Harned, that's the correct way to pronounce that, I hope, you're with NFIB, what type of impact does this have on small businesses, all the regulations?
Right. So we've done numerous surveys on this because regulations have been a perennial problem for small business owners. And honestly, it's always a top 3 problem, second only or third only to taxes and health insurance. Regardless of if it's good or bad as far as how many are coming out of the regulatory state, complying with regulations is a problem for small business owners because 72% of those employers that have 10 or fewer employees are the regulatory compliance officer. They're reading the rule, they're trying to figure out how to comply with it. What are they not doing? They're not managing their business. They're not growing it, they're not managing staff, they're not trying to get new customers. And that, we think, is not helpful for the economy. And honestly, that is very much, I think, why you will see, especially in these heavily regulated areas, more consolidation.
$2 trillion, somebody mentioned earlier. It costs the economy every year. In small businesses, could they pay their employees more? Could they offer better health care to their employees if they weren't paying all these costs for? We don't want no regulations, okay? We just want a happy medium, happy balance. If they had less regulations,
absolutely,
could they help their employees out more?
All of the research that's been done on this has shown that the disproportionate burden is real costs. I think one study recently, $10,000 per employee for small employers to comply with regulation. When you consider the fact that our members at NFIB, on average net $50,000 to $75,000 a year, they're not counting their gold coins. This is real dollars that they can't afford to spend.
Counting their Bitcoins or their gold coins?
Yeah.
Mr. No, same question to you.
I think this is a basic problem. I think, what makes our country great is that it's a free market democracy, and that starts with the free market and all the benefits it can deliver in terms of wealth creation, economic security, jobs, and all the other benefits. Certainly, if there's market failures, those should be addressed, things like, emissions, environmental health and safety standards that I know Emmett feels so strongly about. Those are all important issues that should be addressed by a regulatory system. But we ought to do it in a rational way. I think there should be a congressional requirement that all regulations should do more good than harm.
Mr. Is it Narang? 20,000, not that we're counting, 20,642 new regulations in the Obama administration. How much is enough? How much is enough? How much do you think businesses can handle before we don't have any businesses?
At Public Citizen, I've met many individuals that have lost loved ones due to a lack of effective, strong regulations, that have had children, have asthma due to being sited close to polluting sources. It's very important to hear from all voices in this debate. And so it's critical to hear from small business owners and small business representatives. But I think it's just as critical to hear from the folks, the average Americans that benefit from regulations on a daily basis. We all benefit from regulations on a daily basis.
Can we keep adding 20,000 regulations every 2 terms, 2 administrations?
I
Can we keep doing that?
I have many stories to share where there was a lack of adequate and effective regulation.
Is that the exception or the rule?
Oh, I don't think it's the exception.
I don't think so?
Well, let me say this. As much as it is my honor and pleasure to testify here today, I really would encourage this committee to hear from folks we talk to at Public Citizen and other organizations that work with us that benefit from regulations and that have been dramatically harmed by a lack of adequate and strong regulations.
I yield back my time, Mr. Chairman, that I do not have.
Gentleman from Iowa yields back. Gentleman from Alabama is recognized.
Thank you, Mr. Chairman. I want to begin with the lady from the GAO, Ms. Nugent. In your testimony, in your written testimony, you talked about regularly evaluating whether issued guidance is effective and up to date. Does the GAO have any estimate of the percentage that were not considered effective and up to date of the regulations?
We haven't done work to determine the extent to which how much is done. I want to share an example of an agency who does have procedures in place to review whether or not guidance is current. DOL, for example, has this process in place, and through this process, DOL was able to reduce 85% of its guidance for a sub-agency.
I appreciate that. I'm a big fan of the GAO, by the way. I think you guys do great work, but what I try to utilize your work, so the questions that I'm asking is in the context of how do we improve situation. And so when you have requirements, these are federal, these are requirements imposed on the agencies and they don't comply. I mean, it's great to point out that one does. But they all should. Are there any penalties, any remedies applied for those who fail to comply?
As noted in our report, we've made recommendations to agencies to improve their adherence to OMB requirements for significant rules, guidance, and also to adhere to internal controls for non-significant guidance.
I appreciate that, and I hate to cut you off, but I've only got a few minutes left. That's part of the problem. We see time and time again, it's the same thing with improper payments. There's laws actually passed by the Obama administration, signed by the president, that requires agencies to report their improper payments, but they don't. And the GAO writes a report and has recommendations, but there's no enforcement. That's a huge issue for, I mean, what good does it do to have these requirements if nobody complies?
GAO does not have enforcement authority, although we do have a good record of agencies implementing our recommendations. Generally, we have close to an 80% implementation of recommendations, and we believe this is the case because of the quality of our work.
Okay, I want to make sure you understand, I'm not assigning this responsibility to the GAO. I'm simply pointing out this is a public hearing for the public to understand that we don't require the agencies to comply with the guidelines that we give them. 80% might be a B-. I think we owe it to the taxpayers to be an A+. We owe it to the people trying to create jobs to be an A+. And on another point here, under the Congressional Review Act, agencies are required to submit new regulations for congressional review. Do you have any idea how many regulations that were not submitted to Congress for review?
If I may, I'll handle that question. We do track everything that we receive. So if asked whether we've received a particular rule or set of rules, we can check our database to see. We do not know at this point, for example, in 2017, whether there were rules that were not submitted to GAO. We don't keep track of that information on a daily basis simply because what we do track is what we do get.
Well, it's a problem because in your recommendations and in what you found, you point out that for the most part, they don't comply, and that there's an economic impact of these regulations that really Congress never has the opportunity to respond to. And I just think, Mr. Chairman, that's an issue that we've got to address. And like I said, I don't attribute that to the GAO. That's our responsibility. Professor Perillo, I'm a member of the Article 1 project, which is made up of a bicameral group of members seeking to strengthen Congress by reclaiming its constitutional legislative powers that are now being improperly exercised by the executive branch, which this previous line of question kind of leads into this. Congress as a body has ceded much of its lawmaking authority to the executive branch by writing vague laws that give federal agencies wide latitude to interpret the law in a way that fits their agenda. It's been said that the most dangerous words in any piece of legislation are, "the Secretary shall determine." How many of these problems being considered today could be prevented if Congress wasn't in the business of writing
Professor, the gentleman's time has expired, but you may answer his question.
Thank you, Mr. Chairman.
I do think Congress has a demonstrated capacity to make choices and put details in legislation. Several of the environmental statutes, the 1990 overhaul of the Clean Air Act, for example, really do cabin agency discretion in significant ways. I would note that there's some academic scholarship indicating that the more staff a legislature has, the more it is capable of writing relatively detailed statutes and cabining agency discretion. This is a set of conclusions arising from a comparative study of the different state legislatures. The legislatures that have more staff tend to delegate to the bureaucracy less. That is possibly one thing to consider.
Mr. Chairman, I'd like to make a statement for the record. There were 12,000 guidance documents identified in response to the committee's request, and only 189 were submitted to Congress and the GAO in accordance with the Congressional Review Act. I yield back.
Jim, Alabama yields back. I'll go last. Ms. Nguyen, I'm one of those too many lawyers my colleagues make reference to from time to time. I'm not a subject matter expert here or anywhere else, but I suspect lots of people that are following this issue and maybe that are watching the hearing aren't subject matter experts either. So I get that all of you are experts and the vernacular just rolls off your tongue, but for lots of people, they don't know what a midnight regulation is, they don't know what the CRA is, they don't know what a guidance document is. So with specific reference to midnight regulations, how, if at all, does it impact the CRA?
The midnight rulemaking is defined by the mandate that, in terms of our review, it's defined by a specific period between September 23rd and January 20th. So we were mandated to look at the midnight rulemaking. It's referred to that because of that period. And in terms of the CRA, as I noted, we found that compliance with CRA for the transition period, in comparison to non-transition period, they're about the same. The trend that's important to note is that compliance with CRA has increased over time.
Can you tell us which agencies had the highest rate of non-compliance?
The two agencies that have the highest rate of non-compliance are HHS and DOT, and EPA has the lowest non-compliance rate.
What justification or explanation were offered by the two with the highest rate of non-compliance?
Because of the breadth and scope of our work, we were asked to look at non-compliance, the compliance with midnight rulemaking over the course of 20 years for various procedural requirements. So therefore, we did not have the opportunity to inquire with those agencies.
If I may add, we are taking steps to notify those agencies of their noncompliance, to call to their attention their obligations under the Congressional Review Act.
So you think it's a matter of oversight rather than intentionality?
I wouldn't want to speculate on that. I don't know. We haven't looked at that question.
Is there a correlation between noncompliance and economically significant regulations?
Our study shows that economically significant regulations have a non-compliance rate of about 25% and 15% for significant rules.
All right. For those who have never heard the term before, what is a guidance document?
Guidance are used by agencies to provide timely information to agencies, and agencies also use them to convey how they plan to interpret regulations. Guidance, generally, they're not legally binding.
Whenever you use words like generally, it makes me wonder that there's an exception to that.
The exception is what we discussed earlier with the notion that the IRS views their guidance to be authoritative.
If I heard Professor Perillo correctly, there's no legal force, lay the IRS aside, there's no legal force attached to guidance documents. Are there any legal presumptions attached to it, accepting that it doesn't have force of law? Are there certain presumptions attached to guidance documents?
I cannot speak about the presumption issue. That's really from the perspective of the regulated parties.
Can I ask your lawyer, is there a legal presumption attached in any way with guidance documents? Here's what's vexing me. When I hear the professor say, and I'm sure he's right, that it's not intended to have the force of law or for everyone to conform their conduct, that they still want to go on a case-by-case basis. Whenever I hear the phrase case-by-case, that's just Latin for no guidance. There's no uniformity. If you're going to go case-by-case, which is what I think I understood him to say, then what is the purpose and/or legal effect of guidance documents?
I believe that guidance documents, by definition, are not legally binding on the regulated community. There have been complaints over the years, however, from the regulated community that at times agencies are imposing binding requirements on the regulated community through guidance rather than going through a rulemaking procedure. And I think that's the underlying complaint behind the use of guidance, not where it's used for the purposes for which it's intended, but rather to impose binding requirements that should really be going through a rulemaking process.
Will the gentleman yield for a follow-up question to your point?
Certainly.
The chairman is spot on, and he's in a line of questioning that, quite frankly, is at the very heart of this hearing. Is guidance typically, and where he's going with this is, does it have any other meaningful effect, either through previous jurisprudence or lawsuits where guidance has been used in a way that is connotates a rule or a regulation instead of just guidance? And
I think it would be fair to say that there have been complaints that guidance has been used to impose requirements that should not have been imposed unless they went through a rulemaking process.
Yield back. Thank you, Mr. Chairman.
Well, let me ask one other question. Is there a colorable claim or cause of action if the assertion is that this discretion referenced by Professor Perillo was applied disparately to this group versus that group? Is that a is that a cause of action? Is that a colorable claim from a litigation standpoint that this exercise of discretion was used disparately?
I think actually Professor Perillo might be best qualified to answer that question.
I'm sure he's written a law review article on it. He may direct us to it.
On the question of whether, as I understand your question, whether inconsistency between individual cases would be subject to a judicial challenge, if the context were enforcement, then no, because under Heckler versus Cheney, at least one-off enforcement decisions or decisions not to enforce or to enforce in the first place are not subject to judicial review. If we move beyond the context of enforcement and we talk about agency adjudication, such as permitting or something like that, then if an agency does not follow the reasoning that it used for a prior individual decision and gives no explanation of why it didn't follow that reasoning, then that would be subject to a judicial challenge. So it varies by the type of individual proceeding we're talking about.
Thank you. The gentleman from Wisconsin.
I have all sorts of questions, but at the beginning, I'd like to yield to my good friend, Congressman Palmer.
I thank the gentleman. Just very quickly, in that point about 12,000 guidance documents and only 189 were submitted, there's no place on the GAO form for meaningfully reporting guidance. Don't you think that it would help matters to have that on the form? And Mr. Chairman, I'd like to enter this into the record.
GAO has issued a number of opinions on whether guidance documents are rules for purpose of the Congressional Review Act. It's up to the agencies to decide when they're issuing guidance whether they have an obligation to comply with respect to the Congressional Review Act with respect to that particular guidance document. Does it meet the definition of a rule under the APA? We call them all rules. And when we're asked to consider whether a particular guidance document is a rule for purposes of the Congressional Review Act, at the end of the day, it's a rule.
Well,
and so we call...
I don't want to take up the gentleman's time. I just think you ought to add that on your reform. It might help get a better response.
We'll
I thank the gentleman. I yield back.
Yeah, just a general question. I mean, I'm going back 25 years to my days as a lawyer. And at the time, at least I used to deal with the IRS, guidances were kind of treated as law. And that's why they made the guidances, right? If you brazenly disobeyed the guidances, you were kind of risking the wrath of the IRS. Don't you think that's accurate?
I think that's one of the complaints that regulated community...
Why else would they issue the guidances?
Guidance does serve a lot of useful functions to communicate with the regulated public who, in many cases, would like to know what the agency's thinking about a particular issue.
Right, right. That's exactly the point. If you issue a guidance, it's for a purpose, right? The purpose is to tell the public, be it a business or an attorney or whatever, how the agency will interpret an ambiguity. And if you brazenly go against the guidance, you can do it and hope you're not caught. That's fine. I wasn't afraid to do that. But the reason the guidance is out there is you can expect, if you don't follow the guidance, that if you get caught, you're going to be challenged in some fashion. Isn't that true? I'm sure that's true of other agencies as well, right?
That certainly may be the case.
Of course it's the case. Why do you say it may be the case? Of course it's the case. Why else do you issue the guidance, right? Does anybody else have a comment on that? Isn't that, of course, what the guidance does? It means the agency is going to interpret an ambiguity in a law such and such a way, and if you brazenly disobey the guidance, then you're going to wind up challenged in some fashion. Maybe you'll win in court. It's true, it isn't legally binding, but it does say you could wind up in court, doesn't it?
If I may, answer that question?
Sure.
So yes, if the agency is empowered to proceed case by case, in other words, only on the basis of precedents from prior individual proceedings, then in any future proceeding, it can exercise its discretion and interpret law as it sees best, constrained just by those prior precedents. And so the guidance is a way of saying this is what what we're planning to do in the absence of some argument from the regulated party that we should do things differently. And then if it's guidance, they have to answer that argument.
All right, but why else would you issue the thing? Right. Now I guess the question is, right now, as I understand it, in general, maybe always, there's no public participation on guidance. And that's the benefit of a rule as opposed to guidance. In a rule, if the agency is doing something dumb, maybe, or offensive, it'll come out because you have to have some public input. In guidance, there's no public input. Do you think there should be a little space for public input on guidance?
May I take that?
Sure.
Yes. I really appreciate the question because NFIB absolutely thinks that there needs to be some space for comment. Does it have to go through the whole notice and comment like a rulemaking? No. But the idea that small business owners and other members of the regulated community even know what these are is an issue, much less getting to say, hey, this is how this is going to impact me as a practical matter. Yes, we think that would be a good practice.
Congressman, can I jump into just from my experience, having been at the White House Office of Management Budget, drafting the good guidance bulletin they have, we were very responsive to the agencies that, you don't want to ossify the guidance process because there are a lot of potential benefits to guidance if they're done right. And we agreed, so we just said for the most significant guidance that might have a potential to lead to an economic impact, but we were very clear it's something that reasonably could be anticipated to lead to an impact, not cause it directly, because of course guidance are supposed to not be legally binding. But the agencies made beyond Swiss cheese out of that. In fact, it's so bad, the report that the GAO did in 2015 showed that the agencies said, this is 4 major departments of the government with 25 agencies, we have 0. So we have 0 guidance that should be subject to pre-adoption notice and comment. That's where we are, and that's why I'm saying the White House Office of Management and Budget should amp up that guidance. You all ought to think about legislating a requirement that there be good guidance practices. You've already done it for one agency. In 2000, Congress by statute required the FDA to do a regulation to set good guidance practices. This is an agency that deals with life and death issues, and they've operated, my understanding is, that people are generally happy with the way that works. And I don't see any reason other agencies shouldn't be able to operate at that level.
Thank you.
Could I respond very quickly?
We'd love to have you respond.
Thank you. Thank you, Congressman. Let me just say that if Congress does impose procedural requirements on guidance documents like notice and comment, or on a subset of guidance documents that approximate, what we have with APA notice and comment rulemaking, then I think it's an open question, maybe right now an academic question, but an open question as to whether we should then be giving the agencies the option to make those guidance documents binding. What is the point of an agency going through a robust guidance document process that looks like rulemaking if they're going to have a non-binding document? I think the more realistic outcome would be that they not issue guidance.
Well, I'm just going to respond. No. There are times where guidance is good because you've got to come up with something on a dime to interpret a law that Congress passed or, explain the way the agency is going to treat things. And that's fair. If you're not going to go through all the way through the administrative rule process, you don't want it to become the force of law if it's something less than that. See? But I do think there are times, I'm thinking back 25 years, in which you had guidances that sometimes made, when I was a lawyer, the guidances made absolutely no sense. Or you wonder who in the world thought up this? And I would think if there was a little bit of input from the private sector community, it maybe woken up some bureaucrat over, because I primarily do with the IRS, but there are other agencies too, would have woke them up and say, yeah, man, I didn't think of that. Okay, so you can't go through the whole process because you want to turn something around quick, but enough that your bureaucracies can understand how this guidance looks from the other side of the mirror.
May I respond on that point?
Well, let me just say, I've been uncharacteristically liberal. We're over 3 minutes over his time, so I will let you respond. Can you give us the Reader's Digest version and your response?
There are some agencies that voluntarily undertake notice and comment for precisely the reasons that you just suggested. EPA does this on a substantial number of guidance documents, the National Organic Program at the USDA, other agencies much less so. As Mr. No mentioned, FDA is required by statute to take notice and comment on a large category of its guidance documents. A lot of people are quite happy with that. The difficulty they run into is that they will sometimes leave a document in draft for quite a long time because they don't have the resources to process all of the comments.
The gentleman from Wisconsin yields back. I want to thank all of our witnesses for not just your expertise in a really important subject matter, but also your comedy with each other and with the members of the committee. With that, the hearing record will remain open for 2 weeks for any member to submit written opening statements or questions for the record. If there is no further business, without objection, the committee will stand adjourned.